Hello, this is Mandy O'Callahan with Keller Williams Realty, and I am going to be going through the listing agreement today. All right, let's get started. This is the Tallahassee Board of Realtors listing agreement for exclusive right of sale, and I'm just going to go through line by line and explain this. So first of all, you've got your date of agreement, the date that you sit down with your customers and enter into this agreement. You would fill that out. And then of course, the parties are going to be the brokerage, Keller Williams Town and Country Realty, and then the legal names of your sellers. And just make sure that when they fill out this information that they have the legal authority to be able to do that. So if there's a divorce situation, if it only has one of the divorced couple's names on there and they're already divorced, then that person would sign off. Or if the property belongs to an estate, then you'll want to get a copy of something called a court order appointing the personal representative, and the personal representative would be the person filling out that blank. So anyway, just make sure that you use their legal names and that they're the authorized person to be able to sell the property. All right. And then here you would put the legal description of the property that's being sold. You put in the lot number, or the lot number, the block, which is usually a letter, and the subdivision that's in. And of course, you can go to the property appraiser's website to fill out that information. So for example, you go here and you can search by name or address, and I'll go ahead and put in my address so you can see where to find this information. Okay. So right over here is where you would find the name of the subdivision, your lot number, your block letter. Oops. Sorry about that. All right, and so once you get that information, you can fill out that information in the right here in the legal description clause. There are some properties that won't have be in a subdivision and won't have a lot and block number. In those instances, when you go to the property appraiser's website, you can open up the warranty deed, and instead you are going to see, let me find an example, this right here. This is a Mets and Bounds description, and whatever you do not want to retype this yourself. You want to check that box that it's attached, and you literally want to attach this because you don't want to make a mistake and put in the transpose numbers and put in the wrong dimensions, and then someone's agreeing to sell something that they don't own or less than they own. All right. So you would check that but there, and then you put in the actual property address, a zip code. And then, once you run your comparative market analysis, go over that with your customer, and they decide upon a price, then you will put that price in there. All right. And then here you would put the length of time of your agreement with your seller. I personally like to do 3 months because in this market, if something doesn't sell in 3 months in a seller's market, then usually that means that it's not priced right. And usually at the end of 3 months, somebody's not happy, either you or the seller. What I always just tell my sellers that you can revisit after 3 months and do a listing agreement revision and extend your listing agreement. But I do know lots of realtors that will do 6 months, or you could do a year. It's up to you. You just need to work that out with your seller. All right. So here is a cancellation clause. So in the event that seller decides not to sell the property, then broker may agree to cancel the agreement. And if broker agrees to cancel, then seller agrees to sign a listing agreement cancellation in a separate form to do that, and reimburse broker for all expenses incurred in the marketing of the property, and pay the broker a cancellation fee of X amount. So you may work out a certain amount that you feel that you are due for spending your time and energy and expenses on marketing that property, and put it in there. So clause B, broker may at broker's discretion cancel this agreement upon, and you will want to type in a certain amount of days written notice to the seller. You can't just leave them hanging and not leave them without representation. So make sure that even if it's 15 days in any kind of contract form, it's always good to fill in that blank so that it prevents fraud and your seller fraudulently putting in a different amount of time, and then you going past that date and then it looks like you've breached your contract. So anyway, make sure that you put some kind of number in there. And then this is all the personal belongings that are fixed equipment that goes with the sale, is included in the sale. You want to make sure and go through that with your customer, make sure that they check the appropriate boxes. But just be aware that this contract is just between you and the seller. So this does not necessarily mean what actually is conveyed in the purchase agreement, but this does say these are the things that you are authorized to advertise that are sold with the property. But again, this contract does not include the future buyer in it. This contract is between the brokerage and the seller. So if you forget to check dryer and washer here, that's okay to an extent. I mean, make sure you're advertising the right thing, but what really matters is what is negotiated and put in the purchase agreement between the buyer and the seller as to what will convey with the property. All right, and then of course, if they have anything to be excluded in the sale, make sure that they mark that there, and that's a good reference tool when you're writing up notes and a description in the MLS as to what to exclude in the sale. All right, so clause number 7, seller's representation. So this is very important. Seller's disclosures are very important to prevent future liability and any kind of lawsuit. So the seller warrants that the representation of property furnished to broker by seller are true. Seller represents that seller has legal authority and capacity. We just went over that at the very top, to convey the property with all improvements. Seller further certifies and represents that the property has no known latent defects. Latent means not visible by the eye. So if a buyer goes in and they can't see that there's some kind of leak going on behind a cabinet or under the floors, those are not visible to their eye, and so that needs to be disclosed. All right, so it has no known latent defects or facts that materially affect the property's value. So material is a keyword there. If it's just a scuff mark on the wall or something minor like a scratch on some kind of surface, that does not need to be disclosed because that does not materially affect the value. However, if there's a leak over the garage or there's an electrical component that can cause a fire, those things materially affect the value of the property. So those need to be disclosed. And where this comes from, this legal obligation, is in the case Johnson v. Davis, and you may want to provide a copy of that case to your seller so they really understand their duty to disclose. So here is the court case inciting in case you want to look it up, and the holding found by the court towards the very end I've got highlighted here. So this is where that comes from, that the seller has to disclose those facts materially affecting the value of the property that's not readily observable. That's that latent defect that I was just talking about. All right, so that is that disclosure rule there. And then seller agrees to immediately inform broker of any material facts that may arise after signing the agreement. So your seller, that's an ongoing obligation. If something happens while the house is for sale or while it's under contract, if anything happens that materially affects the value of the property, they need to refill out their seller's property disclosure or somehow let the buyers know that something has happened. That's an ongoing obligation. So seller agrees to indemnify broker and hold broker harmless, this is the hold harmless clause, from losses, damages, costs, and expenses of any nature, including attorney's fees, and from liability to any person that broker incurs because of a seller's negligence, representations, misrepresentations, actions, or inactions, or B, the existence of undisclosed material facts about the property. So basically, not holding the brokerage responsible for something, some act or inaction that the seller takes, including undisclosed material facts about the property. This clause will survive broker's performance and transfer of title. So if the seller in the future, after everything's closed and it's discovered 2 years down the road that the seller did not represent that there is a huge mold problem in the attic, and that's discovered later, this obligation for them to hold the broker harmless survives the closing. All right, clause 8, seller's responsibilities. Seller agrees to furnish brokerage the keys to the property. Seller will make the property available for broker to show to your prospective buyers during reasonable hours. So the seller does not have to allow a midnight showing by any means, or a 7 o'clock showing in the morning. Usually reasonable is sometime between 8 and, I would say, 8 in the morning and 8 in the evening. All right, and then seller agrees to immediately refer all inquiries on the property to broker. So the seller should not be dealing directly with customers. If someone stops by their house, sees your for sale sign, they should refer that person to you, the agent. And to inform broker prior to leasing, mortgaging, or otherwise encumbering the property. So the seller will not enter into any kind of contractual relationship without first advising the sales associate and brokerage. Seller will consult appropriate professionals for related legal, tax, property condition, environmental, foreign reporting requirements, and other specialized advice. This often comes up when a seller is selling a property that maybe they own outright, or they haven't lived in it long, and they may be subject to capital gains tax when they sell it. So just make sure that you are referring them to the appropriate tax professional, or of course, if they have a certain legal question, maybe even about whether they hold the appropriate title to be able to convey the property, make sure you're sending them then to an attorney. All right, clause 9, broker's responsibilities. In consideration of this exclusive right of sale, broker agrees to A, process the property through the multiple listing service within X number of days of execution of this agreement, market the property as broker deems advisable, and C, furnish sales information requested by any broker. So I've been asked before by new agents, is there a certain timeline within you can put in there, if they have a lot of repairs to make and it's going to take some time? Well, you definitely, our goal as agents is to get this listing agreement signed and enter into that contract. So definitely, put it out a ways. If they've got to put a new roof on and the roofers are backed up or whatnot, make sure that you put that out a ways so that you've got time to prepare to have the house ready and then be able to get it into the MLS. It's not fatal if you put 60 days and then turns out, for example, I've worked with relocation companies and sometimes they take a long time. So you can just do a listing agreement revision and, allow yourself some more time if need be to get this into the MLS. And we'll go over that listing agreement revision form in a minute. All right, seller acknowledges that if the property is marketed and or sold prior to being entered into the MLS, the property may not receive maximum market exposure. And my understanding is that this really is about the advertising in a coming soon status. And so if you're advertising maybe just to your brokerage and not getting that house advertised as a coming soon into the MLS, then you know, you may get an offer from someone in your brokerage, but if you put it in the MLS and advertise that as a new listing to everybody, then you may get multiple offers and your seller may get even above what they're listing for. So that's just for your sellers to be aware that they are not getting full marketing exposure when you advertise it as a coming soon that way. All right, clause 10, seller's cost. Seller authorized brokerage to arrange for and obtain all items necessary to consummate a closing on the property as agreed by seller and buyer and directed by the contract for sale and purchase between those parties. Seller agrees to be responsible for payment of these items in a timely fashion of the outcome of the transaction. So part of the job is to help facilitate the closing, maybe arrange for repairs, you know, set up that roofing, but the obligation is on the seller to pay for those things to be able to facilitate the transaction. All right. 11, prorations. All taxes from the current year, assessments imposed by the Community Development District, rents, other income and expenses of the property, and HOA dues, if applicable, should be prorated as of the date of closing. So from January 1st up until the day you close, the seller will pay for those prorated amounts, and then the day of closing to the end of the year, that prorated amount is on the buyer. And in case anyone might not know what a community development district is, there are some neighborhoods that are their own acting governments, and then they charge a certain assessment to run like a government and to be able to afford to cover expenses associated in that neighborhood with like streets, street lights, maybe sidewalks, sometimes a park. So Southwood is an example of that. Southwood has its own community development district. Piney Z has its own community development district. And then each of those have a special assessment that is tacked on to their taxes and paid out of their escrow each year. All right, brokerage fee. A, for finding a buyer ready, willing, and able to purchase property, seller agrees to pay broker no later than the closing date a brokerage fee of, here you can put in a certain amount, or you can put in a percentage. Often you'll see the percentage, which can be 6%, 5%, whatever you negotiate. Sometimes though, a seller will agree to a certain amount, like $6,000. Of the price at any price in terms acceptable to the seller, along with a blank amount of transaction fee. So if you are hiring a closing or a transaction coordinator and they are going to be working with the title company and arranging for the survey and inspections and so forth, you may be charging a transaction fee and passing that on to your seller. Closing is not a prerequisite for brokerage fee being earned. Brokerage fee is due if any interest in the property is transferred, whether by sale, exchange, governmental action, or any other means of transfer, including if seller defaults on an executed contract for sale and purchase, or agrees with a buyer to cancel an executed contract for sale and purchase where buyer is not relieved of obligations to purchase under the terms of any contract agreement. So ideally, the buyer seller go under contract and close on the property and you get paid. But there are other things and circumstances that may happen where you get paid in a different manner and the seller is still obligated to pay your commission. For example, if the state comes in and takes the property and they are paid for that property, then you may be paid a commission in that circumstance. Or if the seller breaches the contract and there is not a good reason under the contract for them breaching that contract, then you may still collect your commission in that circumstance. And then this next part has to do with, well, I'll read it in, it has to do with a part of what I was just talking about. All right, let's see. Brokerage fee is due if any interest of property, whether by sale, exchange, government action, or any other means of transfer, including a seller to defaults, and that's that breach I was talking about, unexecuted contract for sale and purchase, or otherwise agrees with the buyer to cancel the executed contract for sale and purchase, where buyer is not relieved of obligations purchased under the terms of any contract agreement, whether the buyer be secured by a broker or seller or by any other person, or if the property is sold within X amount of months after expiration or cancellation of this agreement to any person whom the said person has been submitted by broker, a cooperating broker, or seller's representatives. This provision survives termination of this agreement. So I'm going to go over this because it's important. What this prevents is say we have a 3-month listing agreement. And then say you're a week away from your listing agreement expiring, and your sign out in front of the lawn brings in a customer who is interested. And say your seller is out in the front lawn and decides to go up and talk to that person. And the person seems really interested in the property. And so how did you find the place? Well, I found it by, looking at your agent's advertising online, and I saw the sign here, and I knew this was the property. And then the seller says, well, if you just hang in another week, then we won't be under a listing agreement anymore, and I won't have to pay commission, and so I can give you a good deal on this house. So this prevents that. So you want to make sure that you're protected by saying, for example, another 3 months after the contract terminates, if someone was brought to that house through your marketing, through your advertising, through your hard work, then you are still to be paid your commission because you brought them in. That kind of prevents the seller from circumventing the listing agreement after you've done your hard work. However, this is an exception. No brokerage fee shall be due to broker if, after this listing has expired, the property is relisted with another broker and sold through that broker's listing agreement. So that being said, if that seller goes ahead and lists with another agent, and that person that they had talked to out in the yard comes back, then they will have to not pay you, but they will have to pay that brokerage. All right, so clause B, in exchange of this property, permission is given broker to receive brokerage fees from both parties. We are presumed to be transaction brokers, so we can work as a brokerage and help the seller and the buyer. And if the buyer also wants to pay you, then having a relationship with the seller does not negate the ability for the buyer to also pay you. All right, clause C, brokerage will provide the following relationship to a seller: the transaction brokerage, which most Keller Williams agents will work as, so they can facilitate the transaction and get paid on behalf of the buyer and the seller. Single agency broker may transition to a transaction broker when required. Seller must sign required consent to transition to transaction broker agreement or no broker relationship. And I was just going to show you the difference, and I know that this will probably harken back to taking your state licensure exams and so forth. But all right, so here are the duties for the single agent notice. And if you were going to operate as a single agent notice, you would want to provide this kind of disclosure. And I'll just let you read through those instead of reading all of them. Versus no broker relationship is a very limited representation. You just need to deal honestly and fairly, disclose all known facts that materially affect the value of the property, and you have to account for all funds. So that's your most limited form of representation. All right, and then here's your transaction brokerage relationship, and that is what most agents' duties. And again, I'm not going to read that because you'll be familiar. So going back to the listing agreement, those are the 3 forms right there of agency. And then clause D, cooperation with other brokers. So this is where we typically split our commission. So if you have an amount up above where we said your brokerage fee is going to be a certain fee amount or a certain percentage, this is where you would split that in half typically. So you would check here, if it was a $6,000 commission, then you would give them $3,000. Or if it was a 6% commission, you would put 3% in here. And then same thing, depending on the kind of agency. Sometimes I see that some people will give certain people less than they're under a no brokerage, but I don't know, to me that doesn't make sense because you want to try and get buyers in regardless so that you can close on the property, but those are your options. All right, so above compensations also apply to contracted reciprocal agreements, if any, with any other board or MLS. So if we recognize anyone with another board. Now there are agents from outside of our board that will come and may make an offer on your property, and you have to work that out if they're going to, and you should probably cooperate with them, but that's a discussion for another day. Clause 13, deposits. If a deposit is forfeited by a buyer, the seller will be entitled to, and then you put what percentage of the deposit. That is up to you, 50%. I personally, the seller is taking their property off the market for the time that they are under contract, and usually that means after 15 days if they're walking away and losing their earnest money deposit under the due diligence clause or financing clause. So I give the seller 100% of that for them having taken off their house off the market for that length of time, and usually means they have to put that towards paying their mortgage. All right, let's see. Clause 14, no verbal agreements. As with most contracts, if you just say something outside of this and it's not in writing and in the contract, then that clause or whatever you said is not valid. It needs to be within the four corners of the document and in writing to be applicable. So seller and broker acknowledge that this agreement does not guarantee a sale, and that there are no other agreements, promises, or understandings either expressed or implied between them other than specifically set forth herein, and that there can be no alterations or changes to this agreement except in writing and signed by both broker and seller. So if you say out loud to your seller, I promise I'm going to sell this in less than a week, well, it is not in writing and not a part of this agreement. Seller warrants there are no prior agreements on this property, listing, sale, or otherwise that have not been terminated. All right, clause 15, non-discrimination. This almost goes without saying, but you need to explain to your sellers that you cannot discriminate when you are showing the property and offering the property up for sale and marketing the property. The property is offered to any person without regard to race, color, religion, national origin, sex, age, handicap, or familial status, or by any other factor of authorization. So the seller, you do want them to authorize the use of a lockbox system. B, seller authorizes broker to place appropriate signage on the property, including but not limited to for sale signs, sale pending riders, and sold riders. Just be aware, just because you authorize, not necessarily that the HOA that the house is in is going to allow signage. So just be aware of what neighborhoods don't allow. They require a certain kind of sign, like Southwood, you have to have the big white posts and you have to have the sign say Southwood and so forth. Some neighborhoods don't allow your directional signs. So just be aware that authorization from this doesn't mean that it might be not allowed in some other way. All right. Clause C, seller authorizes broker to use seller's name in marketing the property. And I like to explain to them in case they're hesitant that anybody can look up their information on the property appraiser's website anyway, because that information is public record, unless they are in a job, like they're a police officer and they're a judge and their information is protected. In those cases, in that circumstance, then they have a statutory exemption and their information does not need to be advertised. All right. Clause D, seller authorizes broker to advertise the property as broker deems beneficial in newspapers, publications, computer networks, including internet sites, and other media to include photos and virtual tours, unless the seller opts out. Underneath, below, we're getting there. Seller has been informed that through the use of these marketing tools, the property will be marketed more widely, and if utilized, a lockbox system will help the property be more readily shown to prospective buyers, but personal property of the seller may be more susceptible to theft or damage. So this is a good spot for you to make sure you educate your sellers to put away and store any, hide any valuables like jewelry, computers, laptops, tablets, and also to put away any kind of medications or make those not accessible, because unfortunately there are people that will go to open houses or showings to try and steal medications and jewelry and so forth. So make sure that they put valuables and medication away. Seller agrees that if utilized, a lockbox system will be for the benefit of the seller. Seller is advised to secure their valuables. There you go. Seller releases broker and those working by or through the broker and Tallahassee Board of Realtors from all liability in connection with any loss that may occur. So just make sure you advise them to put away anything that's important to them. Clause E, seller authorizes broker to report to the MLS system the listing information, price, terms, and financing information on any resulting sale for use by authorized Tallahassee Board of Realtors members, MLS participants, and subscribers. So we definitely need to use the MLS system to advertise the house. All right, Clause F, internet display and virtual office website. So this is going to be talking mainly about your Zillow.com, Homes.com, Realtor.com, Trulia.com. We're talking about those kind of websites. So some brokers offer real estate brokerage service online. These websites are referred to as virtual office websites. An automated estimate of market value or comments and reviews about a property may be displayed, Zillow, in conjunction with a property on some vows. Anyone who registers on a vow may gain access to such automated valuations or comments reviews about any property displayed on a vow. Unless limited below, a vow may display automated valuations or comments, reviews, blogs about this property. So under here is where you're going to want to check these things. So typically, and this is, I'm going to give you the way that I would do it, but you of course can talk with your seller and make your own decisions. So seller, you do want the property to be displayed on those websites. Those websites are very valuable for marketing. So that's good. You want that. All right, and then seller does authorize the property to be displayed on those virtual office websites that we talked about. So you do want it on the internet. You want to advertise on there. You want to be able to have their property on there. You want them on those virtual office websites, which are actually helpful. A lot of people look at them, like Zillow and Homes.com and so forth. And the seller does want the address listed. You want people to be able to look it up and find it on a map and drive to the house. But these are the two exceptions that I personally would say. Typically, the seller doesn't want an automated estimate of the market value showing, because that could be very detrimental if you've decided on, say, $185,000 list price and Zillow is only showing that it's worth $150,000. And then also, you don't want to allow people to write some crazy, like, oh, the house smelled terrible, or the carpet was terrible in that house, and then lose the opportunity for that person to be interested enough to go and actually see it for themselves. So usually I put no on those, but again, make it an educated decision with your seller as to how they want it advertised. All right, clause 17, special clauses. So there may be something really important to the seller in here that's not covered in, what kind of belongings either excluded or included. Or you may have a variable commission where you may say, and you have to be careful with this, because if you have a variable commission, you need to make sure that you check that box in the MLS and let other agents know that you're working under a variable commission. What that means is, say you're working with your seller and you're going to give them a super duper discount on your commission because they are going to agree to use you on the buyer side when they purchase a house. So you may put in here that seller to pay 4% total commission if working with the seller to purchase a property, something to that effect. But if you do a variable commission like that, just be aware that you're supposed to make certain disclosures when you're listing the property so that other agents know that you're getting that discount. Or say you say, I'll only do a 4% commission if I represent both the buyer and seller. And that is definitely instant when you need to represent that to a buyer's agent, so that they know that if they're bringing in a competing offer and you're representing another buyer, that the chances are that you are going to win out because the seller has an interest in you representing both the buyer and the seller, because they're going to pay a discounted commission. All right, so clause 18, legal matters. This is a legal contract binding on all parties hereto and is binding on sellers, heirs, personal representatives, administrators, successors, and assigns. So if you're under this kind of a listing agreement and your seller passes away and the home is assigned to an estate and a personal representative now comes into the picture, then you are still under this agreement. This passes on to them. If seller does not fully understand this agreement, seller should seek competent legal advice. In connection with any litigation arising out of this agreement, the prevailing party shall be entitled to recover all costs incurred, including reasonable attorney's fees. Copy of agreement. So whenever you enter into this listing agreement and sign off on it, both parties sign off on it, then a copy of this is to be presented to the seller within 24 hours of it being fully executed. All right, and then this is where you just put the party's information, your information, seller's information. This does say right here, signature of a sales associate shall serve as acceptance for broker. So it is sufficient if the sales associate signs off on behalf of the broker, and then you're entered into that listing agreement, and you still need to get them a copy of it within that 24 hours. And then the seller's mailing address, seller's email address, and seller's phone number. And then I was going to real quickly go over the, if I can find it, here you go, listing agreement revision. So every once in a while, you may need to change the terms of your original listing agreement. And so you would just enter the information in here and have the seller and yourself sign off on it. So again, property address, the seller, the brokerage that's working on this listing agreement that was originally dated that you're changing. And then these are where you can put in what kind of changes you're making. You can change the price, you can change the expiration and extend the date for your listing agreement. You can change any of the terms in the listing agreement in here. Sorry about that again. And then you can also withdraw in case they decide, well, we haven't sold it, you really do need to renovate that kitchen. So you can withdraw it for a certain period of time for them to do renovations, for example. And then here you go. You just say that this doesn't actually cancel the listing agreement. This is just changing some of the terms. And then you sign off on that. All right, that is it. I hope that you find that helpful. And if you have any questions, I'm always happy to help. And you can go to any of your ALC members as well, and I know they'd be happy to help. My phone number, if you want to text or call me for any help, is 850-339-7639. All right, get out there and do some business. Thanks for watching.